Hello, welcome to This Family Does Everything. My name is Alexandria, and this is part 3 to Judge Dorow versus Darrell Brooks. The flip in this video from part 2 to part 3 is just amazing. So let's sit back, watch, and analyze the Darrell Brooks trial.
There's another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you've been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir, based on law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law or fact?
I'm going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges. And without,
Mr. Brooks, you've been made aware of them multiple times.
I do not understand them, is what I'm saying.
I encourage you once again, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir,
right.
I've already addressed this. Okay. We're not going to have any further argument on this topic. All right. Your Sixth Amendment rights are being honored no differently than any other defendant that has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. An injured party has to make the claim, Your Honor. A living.
Sir, it's my opinion that your belief as it relates to that is mistaken. It's not a lawful argument, and it's frivolous. I've direct your attention once again to the Beneby decision.
Is that not a federal case, a United States?
You're asking me for legal advice. I'm not going to provide that to
I'm
you,
not.
sir.
I'm just asking what kind of case it was. Was it federal Supreme Court
It's a Seventh
case?
Circuit Court of Appeals case. We're in the Seventh Circuit, sir.
But you just stated that you're not a court of appeals. But you're citing a court of
No, but
appeals
Court of
case.
Appeals case law applies to this court, sir. I'm bound by legal precedent from the various courts that are above me.
And you're still not explaining how I'm not able to face my accuser, which is my Sixth Amendment constitutional right.
Sir, I'm not going to explain the law to you. I've made my decision. It stands.
I'm not arguing that part of it, Your Honor. I'm just merely stating for the record.
Yeah, I heard the door.
Okay, thank you.
I'm merely stating for the record that I should be awarded my Sixth Amendment right to face my accuser.
Your objection is noted, sir, once again. We'll continue this morning. Thank you.
None of the witnesses that testify are the accuser. None of the witnesses that testify are the injured party, which a claim has to be made by a living, breathing human being.
Sir, I think you're confusing civil law with criminal law. That's what I'm saying.
No, I'm confusing. I'm not confusing any law. The Constitution says that I have the right to face my accuser. And under the Sixth Amendment, I'm not being awarded that constitutional right. I think that definitely needs to be on record, and that definitely is an issue that needs
Your
to be
objection is
raised.
noted, sir. If you believe I've erred in that regard, you can raise that issue on appeal if you are convicted.
May I put Your Honor on notice that I intend to appeal that decision?
Your statement's noted for the record.
Is that a judicial determination I will not be able to face my accuser, Your Honor?
I have not made any such determination, sir.
Will you be making a judicial determination?
Sir, I have not made any kind of determination that your Sixth Amendment rights have been violated. On the contrary, I believe this court has honored those rights.
Even with me not being able to face my accuser, which is the state of
Your
Wisconsin, the
position
plaintiff.
is noted, sir.
Is
It's
that a
noted for the
judicial
record. I've already addressed it.
Is that a judicial determination?
Sir, the record speaks for itself.
Is that a judicial determination?
All right, I believe the jurors are coming out. All rise, please.
Are you going to answer that, Your Honor? Or is
No.
that a tacit agreement?
I'm not going to answer that further. I've answered it multiple times.
Is it a tacit agreement?
It is not.
Then I should be awarded my Sixth Amendment right to face my accuser. Or a judicial determination should be made.
Record to reflect that the jurors are coming in for the morning. Good morning, ladies and gentlemen.
The record should also reflect that I received no answer to that question.
And good morning to the remaining jurors who are filing in. Of course, we stand for you, so when you come in, you can have a seat. And thank you, everyone. Please be seated. State may call its next witness.
Thank you. The state will call Stephanie Bonesteel.
And you testified that you did not see the driver. Would that be fair to say?
Yes.
Do you recall giving any police report or being interviewed by any law enforcement?
Yes.
Do you recall if that was the same day of the incident or in the days following?
I gave my statement to a police detective on Friday of that same week, the day after Thanksgiving.
So that would be around the 26th of 2021, November the 26th of 2021. Would that be fair to say?
I believe, yes, it would be November 26th.
Do you recall why it would take almost a week to be interviewed or to make a report?
Objection,
Grounds.
argumentative beyond the scope of the witness's
Grounds.
knowledge.
Grounds.
Also calls for speculation on the part of the witness. It's sustained.
Do you remember who the law enforcement officer was that you gave your statement to?
He was a detective with the Waukesha, City of Waukesha Police Department. I do not recall his name at this time.
You stated that you don't recall seeing the path of the traveling vehicle after it had passed you. Would that be fair to say?
I did not see the vehicle once it had traveled beyond my husband's vehicle.
Did you see it strike anyone at that point?
I saw it strike a person when it was parallel next to my husband's vehicle.
Did you see it strike anyone after that point?
No, I could not see the vehicle past that point.
Did you see the vehicle strike anyone before it got to the location that you were at?
No, I did not.
Do you recall reading or seeing a complaint in this matter in any way?
Objection.
Grounds.
Sustained.
To the best of your knowledge, have you filed any claims in this matter?
No, I have not.
Would you consider yourself to be a party to this matter?
Objection.
Grounds.
Relevant.
Sustained.
Were you aware that it might be a possibility that you would be called to testify in this matter?
Yes, I did.
Were you in fact subpoenaed by anyone to testify in this matter?
Yes, I was.
Do you recall by whom?
By the state of Wisconsin.
And when you say the state of Wisconsin, who do you refer to?
Objection. Argument
Grounds.
clear.
Sustained.
Have you had any interactions with the state of Wisconsin?
Objection.
Grounds.
It's vague. Sustained. You may rephrase if you so choose.
Did you have any phone conversations or any physical conversations with the state of Wisconsin?
Objection.
Grounds.
Sustained. You can rephrase if you would like.
Do you even know the state of Wisconsin?
Objection.
Grounds.
Argumentative.
Grounds.
Sustained.
It would be fair to say, based on your testimony, that you were in fact called to testify by the state of Wisconsin.
Objection. Asked and answered.
Grounds. I didn't even finish the question. And I had the grounds on that.
Finish your question and then I'll rule.
Seeing as how that you were called to testify by the state of Wisconsin, it would be fair to say that you've actually saw the state of Wisconsin.
Objection.
Grounds.
It's vague.
Grounds.
Sustained.
To the best of your knowledge, would the state of Wisconsin be the plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained.
And I had the grounds for the sustain.
Sustained.
Your Honor, with all due respect, the jury needs to know
question.
this. They deserve to know this.
Next question.
Are you aware that, to the best of your knowledge, are you aware that for a case, there has to be an injured party?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained.
As you said, the state of Wisconsin called you to testify. Did they at any time identify themselves as an injured party in this matter?
Objection.
Grounds.
Argumentative.
Grounds.
Irrelevant.
Grounds.
Sustained.
Reason for the sustain, Your Honor?
Continue, Mr. Brooks.
Any reason for the sustain?
It's sustained.
May I have the grounds, Your Honor?
Keep going, Mr. Brooks.
This is information that the jury deserves to know, Your Honor.
The jury is the judge of the facts only, and the court is the judge of the law. Keep going, Mr. Brooks.
No further questions.
Any redirect?
No, Your Honor.
All right, thank you, ma'am. You may step down. You may call your next witness.
Thank you. The state will then call Adam Bonesteel.
Driving in the parade, I generally, want to know where my walkers are, so I'm always in my mirrors, watching my speed. They come up, they grab candy off the trailer to throw to the crowd. So, you have to be very alert.
Okay. Now, you've driven in parades before.
Yes.
Because you're a good husband.
Yes.
Okay. And
Overruled.
the,
Go ahead.
thank you, Your Honor. Would you say that, consistent with your practice, did you do that in this float? You're constantly aware of what your surroundings were. And people walking with your group.
Yes.
The people ahead of you and the people behind you as well.
Correct.
Okay. Do you know downtown Waukesha pretty good or okay or
No.
not very good at all?
No.
Okay. Did you learn later that Jane passed away due to her injuries from this collision?
We did learn that later. My gut feeling in that was that she had passed.
You mean when you went up and saw her?
Yes.
You felt she was either dead or close to death?
Yes.
Thank you, sir. I don't have any other questions for you.
All right, Mr. Brooks, do you have any questions for this witness?
I do. Whew. I apologize. I just needed a quick second. At some point in your testimony, you stated that you heard, or rather you saw, brake lights. Would that be fair to say?
Yes, I did.
To the best of your knowledge, what would be the only time you would see brake lights on a vehicle?
The point right before Jane fell off the hood.
I think you misunderstood my question. If you were driving the vehicle, would it be fair to say that the only time anyone would see brake lights would be if you hit the brake?
If the driver hit the brakes, the brake lights would go on the vehicle.
So it would be fair to say that the only way that you would see brake lights would be if the driver of the vehicle hit the brakes.
That would be correct.
You did state in your testimony that you did not get a look at the driver. Would that be fair to say?
That was never part of my testimony. Nobody had asked me that question. Are you asking me that question if I had seen the driver?
I do recall you saying that you did not see the driver, so I guess that's...
In my testimony?
Yes.
Oh.
Hold on. He's going to ask you a question, and I'm going to ask that you answer that, okay?
Okay.
So go ahead, ask your question.
Did you at any time see the driver of the vehicle?
No.
You did testify to, when you were describing what you saw, you referred to the driver as he. Any reason why you would refer to the driver as he if you did not see the driver of the vehicle?
That would be like the proverbial we.
Well, there's males, there's females.
There are singles and there are togethers. I mean, when you say we, it's the proverbial we.
So
Collectively, he would be along those lines as well.
is it fair to say that you could have just answered as we instead of he?
Objection.
Grounds?
Argumentative.
Sustained. Next question, sir.
Out of grounds on that?
It's argumentative. Rephrase your question.
Any reason why you would answer that question as he?
Objection. Irrelevant. Argumentative.
Grounds.
Asked and answered. Sustained.
Were you able to get a license plate of the vehicle?
No, I was not. I was focused, like I had said, on the body on the ground. So I did not get the license plate.
After the vehicle had passed the vehicle that you were in, did you see the vehicle strike anyone after that point?
I did not see the vehicle strike anyone after the vehicle had passed me, other than driving over, like I had stated, the body that it had already struck.
Did you observe the vehicle strike anyone while it was approaching your position?
Clarify your question, please.
Did you observe the vehicle strike anyone while it was approaching your position?
Yes, I saw it hit Jane.
While it was approaching you?
While it was coming
Or
up.
your vehicle, rather?
Yes.
Did you observe the vehicle strike anyone else in that moment?
No, just Jane.
All about what time it was at that moment?
No. These are thoughts that you don't think about when you've been through something like this. I didn't sit there and note down times. I'm not trained in this.
Do you recall if it was still daytime or nighttime at the
Well, the parade started around 4:30, so it gets, and it was cloudy, so it was dusk. I mean, city lights were on. Emergencies vehicles, when they were pulling up, you saw the sirens, on the streets. You saw it was dusk. It was getting dark.
Would it be fair to say from the Exhibit 46 video that you were shown that it was pretty clear?
Again, wasn't focusing on the sky.
Do you agree or disagree the video or that you saw was clear? That was the question.
The video, the clarity of the video or the skies? Please clarify
that
your
it
question.
was pretty much still daytime. You can see everything pretty clear. Everything was.
You can see, yes, it was clear. It was dusk. Lights were coming on. If the city lights, street lights were coming on.
Would it be fair to say you can recall lights coming on, but not the driver of the vehicle?
I think that's asked and answered, Your Honor.
Objection. Grounds.
Overruled. He may answer.
I can remember lights coming on because they are stationary. The vehicle was traveling past me at a rate of speed with a woman that I thought was my wife on the vehicle. Was not really paying attention to who was driving the vehicle. Again,
So would it be fair to say you were paying attention to the lights?
no.
So what would lead you to believe that they were in fact coming on at that time?
Objection. Argumentative,
Grounds.
asked and answered.
The video that I
Hold on. There's an objection. I have to rule on it first. That's okay. The objection is sustained. Next question, sir.
Do you recall the duration of time that you saw the brake lights?
no, I do not.
But you did in fact see brake lights.
Correct.
No further questions.
Any redirect?
Yes, briefly. Sir, after you saw brake lights, did you see the SUV or the red vehicle that you described ever come to a complete stop?
No.
Objection.
Did you?
Well, there's been an objection. It's overruled. His answer may stand.
Did you at any time see the driver of the vehicle pull over, stop, and get out to investigate what he or she had just struck?
Objection.
Overruled.
No.
Did you ever see the vehicle come to a complete stop at any time?
Objection asked and answered.
Sustained.
That's all. Thank you.
Thank you, sir. You may step down. Statement called. Next witness.
So I'm going to show you what's been marked as State's Exhibit 15. And I'm just going to have it viewed in front of you initially. Do you recognize generally this map?
I do.
And do you see the position that you and your family were on November 21st of last year?
I do.
And do you see your daughter's name in a box that's above the word steaming cup?
I do.
And it's connected to a star that's orange in color?
Correct.
Is that the approximate location of where you and your family were when your daughter was run over?
That
Your foot
is.
was run over? May I publish it to the jury? It's previously been admitted.
You may.
Again, showing the jury State's Exhibit 15, if you can circle the orange star that's associated with where your daughter was struck. Thank you. And the approximate location that you observed the woman to your left?
Objection.
Overruled. You may answer.
And to your right? Next, I want to show you what has been...
Before you move on, I just want the record to reflect, because it wasn't screen captured, that the stars that he circled on Exhibit 15...
Actually, sir, before, so we can capture it, can you again circle the area where you and your family were?
Objection already.
Overruled. He may do it again since it was cleared before we captured it.
And then the area where you saw a body down on the ground to your left? And that's, you indicate that she had plaid pants, or it was a woman who had plaid pants?
Plaid, looked like pajama pants.
Okay.
Correct.
Do you recall what else she was wearing?
I don't.
Okay. And then to your right. Okay. And that would be the circles, if we can save that and mark it as 15. Hang on. Okay.
I think we're on B as well. It'll be marked as Exhibit B.
Thank you.
Sorry, 15B.
And where you marked the circle to your left, that was associated with the same place where there's a name Jane Kulik?
Yes.
Overruled.
And where you circled to the right, there are 7 different names under dancing grannies. Is that fair?
Leaving the
Overruled. You may
witness.
answer.
Yes.
Thank you.
I'm sorry, I didn't hear the last part that you said, Mr. Brooks. Are you withdrawing that?
No, I'm not.
What did you say then?
I said it's pretty obvious from the picture. It's leading the witness.
All right, your objections noted. It's overruled. His answers may stand.
Thank you. Sir, I'm next going to show you Exhibit 49, which is a video. I'm first going to have it played or put in front of you on your screen. If you can just let me know when you see the depiction on that screen.
I see it.
And you saw first couple seconds of that. Let me play it one more time and then ask you if you recognize that. Okay. I stopped it at 3 seconds. And do you recognize that area?
I do.
What is that area?
That's the corner right in front of People's Park where we were at the parade.
Okay. And you had said, is People's Park across from Steaming Cup?
Oh, sorry, Steaming Cup. Yeah, People's Park is directly across from Steaming Cup.
And that would have been the corner that you were located with your family?
At the Steaming Cup corner. Correct.
And do you see yourself depicted in this video?
I do.
Do you believe it accurately represents what you observed that day and what you did?
I do.
Okay. I would ask that Exhibit 49 be admitted into evidence and published to the jury.
For the record, how long is the video clip?
It is 8 seconds.
All right, thank you. Exhibit 49 is received. Permission to publish is granted.
Thank you.
Noted for the record, Your Honor.
It is.
Okay, if we can play it starting at 0, going through the entire 8 seconds. Thank you.
All right, any questions for this witness?
Yes. Just 1 second. Do you remember what time it was when you observed the vehicle?
I don't recall the specific time I saw a red SUV. No.
You stated earlier that you saw the vehicle clip the corner. Would that be fair to say?
I saw it clip the corner of where the children were standing, correct.
And what do you mean by clip?
Come into contact with children that were in the front of that group of kids.
Is that how you would define clip?
That's my definition of clip, correct.
You stated also that it veered quickly away from, I'm guessing, that corner. What do you mean by veered quickly away?
The vehicle at one point was coming straight at us, and then the next moment it was heading 45 degrees back on the original route, so it quickly turned to get back onto the street. Otherwise it would have come onto the corner, onto that intersection at Clinton Street.
So it's fair to say if the vehicle did not quickly veer, as you say, it would have ran right into the people on the corner.
That's a fair statement, yes.
Is it also a fair statement to assume that the vehicle veered quickly away from that because it didn't want to strike the people on that corner?
Objection.
Grounds.
Speculation.
Grounds.
Sustained. Calls for speculation on the part of this witness. You do not have to answer.
In your opinion, why would the vehicle have quickly veered?
Objection again.
Grounds.
Speculation.
Grounds.
Sustained. Calls for speculation.
If you were driving the vehicle and were able at any time to see people directly in your path, would you veer away?
Objection. Relevance for this
Grounds.
trial.
Sustained.
And I had a grounds for the sustain?
It's not relevant for this witness to answer that question. Calls for a hypothetical that he has not been qualified to answer. So it's also on foundation grounds.
You also stated that at one point, after you were observing the path of travel of the vehicle, that it felt like it was straightening up into the middle of the parade route. Would that be fair to say?
Yes.
What do you mean by it felt that way?
Maybe in an incorrect term on my part. My memory, my recollection of the memory was that when it veered off, it went on and continued down the middle of Main Street.
So would it be fair to say that you really don't recall?
I certainly recall the vehicle heading back down Main Street, down the middle of Main Street.
I'm referring to you saying that it, what it felt like, as opposed to what you recall it doing.
I used the incorrect term there. When I said felt, it was more of the word choice of recall I should have used.
Are you aware of the plaintiff in this matter?
Objection. Relevance.
Grounds.
Sustained.
Ever had any contact with the plaintiff in this matter?
Objection.
Grounds.
Vague. Sustained.
Ever had any phone conversations or personal interactions with the plaintiff in this matter?
Objection.
Grounds.
Again, with regard to the nature of the question, it's vague.
Sustained.
I don't believe that's vague, Your Honor. I asked specifically if there were any phone conversations or personal interactions. I don't think that's vague. I think that's pretty clear.
Sustained.
And I also believe the jury deserves to know if there is a plaintiff in this matter.
Your objection's noted. It's to that particular statement. Your statement is noted. To the objection from the state, it is sustained. Next question, please.
Are you aware if there even is a plaintiff in this matter?
Objection.
Grounds.
Sustained.
May I have the grounds for the sustain, Your Honor?
Relevance.
I would object and say that it's very relevant. Again, citing
Your
that.
objection is noted. Next question, please.
Were you ever contacted by anyone who identified as the plaintiff in this matter?
Objection.
Grounds.
Sustained. It's still vague.
That's pretty clear, Your Honor. The jury deserves to know this
Mr.
information.
Brooks, the objection has been sustained. Next question, please.
No further questions.
Thank you. Any redirect?
Briefly. Sir, at cross-examination, you had testified that you did not see any brake lights. Is that correct?
That's correct.
Objection.
Ground.
Relevancy.
Overruled.
Sorry, correct, yes.
Okay. You testified further on cross-examination that you observed the red SUV strike an individual to your left. Is that correct?
Objection. He also stated that he was focused on his children and not focused on...
That's an argumentative statement. What's the legal basis for your objection, Mr. Brooks?
That is hearsay.
Overruled.
I did not see the individual to my left get hit. I just saw her on the ground, or the victim on the ground.
After you saw her on the ground, did the red SUV stop?
Objection. Hearsay.
Overruled. You may answer.
I did not see the red SUV from that duration of the parade. I didn't see the red SUV until the vehicle had already passed that position and came around the other large SUV. So I can't speak to what happened back there.
Was there anything that you could see in the roadway that would have prevented that red SUV from stopping before it started veering towards your group?
Objection, hearsay. You didn't see. You couldn't
The
see
objection to
above that.
hearsay is noted. It's overruled. You may answer.
Can you ask the question again, please?
Certainly. Did you see anything in front of you that would have prevented the red SUV from stopping as it passed that car that obstructed your view initially?
Objection, irrelevancy.
Overruled. You may answer.
Nothing that I saw would have stopped him. That wouldn't have allowed him to stop.
And after he impacted your group that was watching the parade and it continued on towards the dancing grannies, was there anything that you could see that would have stopped the red SUV?
Objection, who's the he you're referring to?
I don't understand the objection. Were you done asking your question?
I was.
Overruled. You may answer.
I don't consent to being called he. We don't even know the he that's being.
Overruled.
The witness didn't identify a he.
Overruled.
I don't recall seeing anything in the road that would have stopped him from stopping, prevented him from stopping.
Thank you. Nothing further.
All right. Thank you. You may step down. This will be an excellent point to take our mid-morning break. We'll be in recess for about 15 minutes. All rise for the jury, please. And the state should be ready to call its next witness.
Still appearing by a third party for my client in this matter. As a living human being. Also would like for the record to address subject matter jurisdiction again, Your Honor, if you would like to answer that now.
No, I would not. And will not.
Is that a judiciary determination?
The record stands. I've previously addressed that issue.
So you will not be answering that.
All right, the record should reflect the jury is coming in.
Is that a tacit agreement again, Your Honor?
I'm not answering that.
So is that a yes or no? I'll take that as a yes for the record, Your Honor.
That's not either, sir. I'm not answering
You didn't
that.
reply. Remember, non-response is consent.
All right, thank you, everyone. Please be seated. Statement call its next witness.
The state would call Heather Rashadi. Did you see the vehicle prior to it striking Owen strike anyone?
I didn't.
Did you see the vehicle strike anyone after it struck Owen?
I didn't.
Nothing further. Oh, sorry. Nope. We'd ask that a screenshot be taken of State's Exhibit 51. I believe that would be 51A.
Objection.
And we'd ask that it be admitted into evidence.
Objection.
Overruled.
My objection was to clarification on whether she was done or not.
I believe it is 51A. It is also captured, and did you move that one in to evidence?
Thank you.
Sorry, did you move 51A?
I did.
All right, and 51A is also received.
And the state would have no other questions for this witness. Thank you.
All right, any questions, sir?
Yes. You stated a few minutes ago that at one point before the vehicle came through that you were having a conversation to the effect of things were going slow, they're not going to get hit?
I never said I was having a conversation.
Well, let me back up. Who were you talking to when you said everything's going slow, pretty slow, they're not going to get hit?
Another mom.
So would it be fair to say that's a conversation?
Yes.
And why did you make reference to getting hit at that point?
Because I didn't expect my kid to get hit at a parade.
So you had already made the determination that they were going to get hit at a parade at that point?
Objection.
Grounds.
Argumentative, sustained. You do not have to answer that question.
Why would getting hit be in your head at that point?
Objection.
Grounds.
Relevance.
Grounds.
Overruled. She may answer the question.
I wasn't concerned about my children being hit at a parade because typically at a parade floats are going very slow.
It still doesn't quite answer the question because the statement was things are going pretty slow, they won't get hit. What prompted the statement they won't get hit at that point?
Another mom was concerned about how much into the street the kids were waiting for candy.
So it'd be fair to say that the initial concern was from another parent
Correct.
and not yourself.
I wasn't worried about my kids getting hit at a parade as I shouldn't have been.
You stated also that you dropped your other kids off before seeking medical attention. Would that be fair to say?
I said that.
Any reason why you didn't seek medical attention immediately?
I did seek medical attention immediately.
You also just stated that you dropped your other kids off. And
My
then,
house is on the way to the hospital, so I dropped 2 of my children off so they wouldn't have to sit at the hospital.
So your intention at that point was to seek medical attention.
I sought medical attention.
Was
Yes.
that your intent?
That's what I did.
Was it your intent?
Objection. Argumentative.
Grounds.
Sustained. Asked and answered.
Do you recall about what time you arrived at the parade?
No.
You recall what time you left the parade?
No.
Do you recall if it was the same night of the incident?
I gave a report the night of the incident at the hospital.
And did you follow up on that report at any time?
No, I didn't.
Any reason why?
Why would I follow up?
Well, it would be fair to say, would it not, that after making a report to law enforcement, you would want to follow up maybe to see what's going to be done about the report. Would that be fair to say?
I knew that the police were going to do their jobs, so I didn't have a reason to follow up. They contacted me when they needed to contact me.
So it'd be fair to say you just gave the report and then just left the rest up to law enforcement.
Sure.
And I'm assuming that law enforcement at some point got back in touch with you. Would that be fair to say?
Correct.
Do you recall about when that was?
Either the next day or the day after.
Do you recall if it was a detective or a regular officer?
I believe it was a detective.
Do you recall the name of the detective?
No.
Were you at any time given a card by the detective to be able to keep in contact?
I don't recall.
Do you recall if your interview was written down as a summary or if it was recorded?
I think he did both.
Did you file any claims related to this matter?
No.
Ever read or saw a complaint in this matter?
No.
Grounds.
Sustained. You may rephrase if you want. But it's sustained as to the form of the question.
Whom were you contacted by in regards to possibly testifying in this matter?
I don't know. Probably the DA's office. I don't know.
Were you subpoenaed?
I was subpoenaed to be here.
Do you recall who that subpoena was from?
I don't know.
So it would be fair to say that you received a subpoena and never read who it was from. Would that be fair to say?
From the state of Wisconsin.
When you say the state of Wisconsin, who are you referring to?
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustain.
Not relevant.
Will you consider yourself an injured party in this matter?
I was not physically injured myself.
Have you filed a claim in this matter in any way?
Has to be answered.
Sustained.
Would you consider yourself to be the plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustain.
Not relevant. Also under 906.11.
Are you aware of any plaintiff in this matter?
Objection.
Grounds.
Sustained on relevance grounds.
Ever had a conversation with the plaintiff at any time in this matter?
Objection, relevance.
Grounds.
Sustained as to the form of the question. You may rephrase it if you would like. Some more specificity.
Have you ever had any phone conversations or personal interactions with the plaintiff in this matter?
Objection, vague.
Grounds.
Sustained as to the form of the question. You may rephrase it if you so choose with more specificity so that it's not vague.
Are you aware of the identity of the plaintiff in this matter?
Objection.
Grounds.
Not relevant.
Grounds.
It's not relevant. Sustained.
Are you aware if there is a plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained
Grounds for the sustain.
on relevance grounds. Also under 906.11.
With all respect, Your Honor, the jury deserves to know this information. We're withholding important information from the jury. They deserve to know this.
The jury will disregard the statement made by Mr. Brooks as not being an accurate statement of the law. Next question.
So to the best of your knowledge, you're not aware of any plaintiff in this matter?
Objection.
Grounds.
Sustained. Mr. Brooks, please move on to another topic under 906.11. You are hereby advised that if you do not move on to a new topic, I will close the cross-examination.
With all due respect, Your Honor, this is important information the jury deserves to know.
Mr. Brooks, ask a relevant question, please.
That holds a lot of relevance, Your Honor.
Mr. Brooks, one last opportunity to ask a question. Otherwise, the court will declare the cross-examination closed under 906.11.
No further questions.
Can you redirect?
No, Your Honor.
Thank you, ma'am. You may step down. Statement called. Next witness.
Daniel Knapp.
It is captured. We'll save it as 51B.
I'd also ask.
Hold on. I'm sorry, was there an objection?
Yes.
The basis for the objection?
Relevancy.
It is relevant. 51B has been captured, and I believe you had a statement about it.
Yes, I'd ask that be moved into evidence.
It is received. 51B.
The objection be noted for the record, Your Honor.
It already has been. Yes, it will be noted.
Sir, continuing to look at 51, you had stated that the direction of travel then was towards the middle of Main Street. Is that correct?
That is correct.
Could you see what it was going towards?
So at the time of when that vehicle was coming towards our group, myself in particular, I saw the driver of that SUV coming right towards me and then start making a little bit of that, I guess, turning instead of the northwest direction, turning more to the west. And at that time, my concern after looking at this vehicle was realizing that he was heading directly for our children. And as the vehicle passed myself and getting to the end of our group, which again, Kelsey was furthest on the west, and right next to Kelsey would have been a family friend, Brinley Harris, and I saw the vehicle strike my daughter. My daughter flew approximately 15 feet towards the middle of the intersection of Clinton and Main. So at that point, a fatherly instinct kicked in, and my sole focus was at my daughter at that point. So I did not have any contact, visual contact with the vehicle after that point.
So you said Kelsey flew approximately 15 feet into Clinton Street?
In estimation.
Your objection is noted. What was the objection?
That was already answered.
That's not my recollection, so it's overruled. I believe she was seeking clarification or additional details.
Can that be clarified in the question?
No, go ahead and ask your question. Attorney Busy. Your objection's noted. It's overruled.
Is that a judicial determination, Your Honor?
Go ahead, Attorney Busy.
So what did you do upon seeing that?
So after seeing my daughter get hit as the vehicle was turning again into the parade route, noticing my daughter was hit by the front right side of the vehicle, and watching my daughter and where she ended up was my sole focus. I ran over to her to check on the condition she was in.
So you actually saw the red SUV's front right bumper strike your daughter?
That's correct.
Okay, and that's what caused her to be propelled into approximately 15 feet away?
That's correct.
What did you notice once you got to your daughter?
I noticed my daughter had a significant amount of blood on her face. She was conscious, but I would consider it a look of, now mind you, she's 3 years old, a look of just complete fear and misunderstanding, just not understanding what just occurred.
What did you do?
So I picked up my daughter, and not knowing exactly the situation that we were currently involved in, not knowing if there was another vehicle, just not really understanding the situation, I picked her up and I ran north on Clinton Street for about 10 yards. I stopped at that moment. I turned back towards Main Street to make eye contact with my wife and the rest of the group, to ensure that the rest of the group was safe, and just to get a bearing of where we were after making eye contact with my wife. And asking the question, is everyone else safe? I proceeded to run with Kelsey in my arms. We were parked at Waukesha State Bank, which I grew up in Waukesha, so thankfully I'm very familiar with the surroundings in this general area, and I knew how close I was to the hospital. I ran with Kelsey. My brother-in-law caught up with me and came with me as we drove up to Waukesha Memorial Hospital and brought Kelsey into the hospital.
What injuries did Kelsey receive as a result of being struck by the red SUV?
So Kelsey received a tear in her spleen in this location.
And for the record, I just want to show that you pointed to the left side.
Correct.
Of
back left side of Kelsey.
Okay.
She received a broken nose, significant road rash and cuts to her facial area, which one of them required some facial surgery.
Prior to the vehicle striking Kelsey, when you first saw the vehicle, did you hear it honking its horn?
I did not.
You stated that the vehicle was coming right at you. Were you able to see inside the vehicle?
I was.
How many people were inside that vehicle?
I could only see one person in the vehicle.
Presumably the driver?
Yes, it was on the driver's side, front driver's side.
Could you tell male or female?
Yes, it was a black male, and at the time, the eyes is what drew me in. Were completely wide open, and made eye contact with the individual driving the vehicle.
So you looked eye to eye with the person who hit your daughter?
I did.
Did you see him in the courtroom today?
I do.
Can you point him out by where he's seated and what he's wearing?
He is seated
I
in.
ask that Mr. Brooks take off his face mask.
Thank you, Mr. Brooks.
He is seated at the table located over here. He's got a gray suit on, a blue shirt, and a tie.
Let the record reflect that witness has identified the defendant, Darrell Brooks.
Objection, I do not consent to being called that name, nor do I know any individual by that name, Your Honor. My name is Darrell Brooks Jr.
The record will reflect that the witness has identified the defendant as the driver of the SUV that struck his daughter.
May my objection be noted for the record as well, Your Honor.
It's noted.
From your observations, you didn't see anyone else in the car, correct?
I did not.
Did the defendant, was he flailing his arms? Do you recall where his hands were?
I do not recall any hand movement. My main recollection is the face, specifically the eyes.
Do you appear to be in control of the car?
Yes.
So you indicate that you were friends with Matt Harris and his family?
Objection. Relevancy
Overruled.
to this particular witness.
Overruled. It goes to context and background.
Grounds for that.
Context and background. It's also relevant. Go ahead, you may answer.
That's correct. We are.
And you say that Brindley was standing near Kelsey when Kelsey got hit?
Objection. Relevancy.
Overruled.
Brindley was standing directly to Kelsey's left, to her east.
And did you see Brindley after November 21st?
Yes, I've seen Brindley after November 21st.
Shortly after November 21st of last year?
Objection. Relevancy.
Overruled.
Yes.
Did she have any type of medical dressing on her at that time?
Objection. Relevancy.
Overruled.
Grounds for that.
It's relevant.
Yes, she had a full cast on.
All right, thank you. Any cross, Mr. Brooks?
Yes. You may claim that you locked eyes with the driver of the vehicle. Would that be fair to say?
That is correct.
And approximately how far was the vehicle from you when you supposedly locked eyes?
I would estimate it 20 feet.
Would it be fair to say that That's about as far as I am from you now? Or was the vehicle further than where I am now from you?
I would state that it was probably a little bit closer.
And what do you mean by a little bit closer?
I would say perhaps halfway, maybe three-quarters of the way between where you're seated right now and where I'm seated right now.
What would be 3/4 of the way? Can you like point about where?
Again, I estimated at about 20 feet. So,
would it be fair to say that halfway between you and I would not be an accurate statement of 20 feet?
Objection.
Grounds.
Overruled. He may answer the question.
that's why I stated it was about 3/4 of the way.
So about what spot would it be? By this black? I guess I don't know what that is. I don't know if that's a door.
Electrical box.
Excuse me. What is that?
It's an electrical box.
Would it be by this electrical box? Would it be this square directly next to the electrical box? I mean, what would you say would be 3/4 of the way?
So the electrical box would be a good estimation of the distance. However, it was a little further to my left than where the electrical box was because it was coming at us at more of a...
So it would be a little further this way, coming back towards the table here.
Your Honor, I just ask that the defendant allow the witness to answer the question before he asks the next question.
And I agree. The record should also reflect that as the witness was answering the question, he was motioning with his left arm in a direction outstretched kind of from front of his body to the left of his body, probably at a 45-degree angle to demonstrate that his observation of the vehicle was in that direction. You may ask the question again then so the witness can answer from there.
So you would estimate that it was in relation to where the electrical box is, probably approximately around like this general area right here?
To my direction, probably a little bit to the left of there.
Just so the record is clear, Mr. Brooks is standing up at his table. He's pointing what would be pretty much directly in front of him, but to my left of the electrical box. We have large squares of carpet. It would be a square and a half to the left, my left, Mr. Brooks' right.
For the record, I'm a third party, Your Honor. Like that stated for the record, I don't identify by that name or consent to being called that name. My name is Darrell Brooks Jr.
Your lack of consent is noted. Next question, please.
Your Honor, just for the record, I don't think some of the jurors in the back can see the black electrical box.
Sure. Why don't we have our jurors stand for a moment so that we can be clear that they're seeing that. Thank you. All right. So the record should reflect that the jurors are all standing to take a look at where the electrical box is and, of course, the squares of carpet next to that. All right. Thank you. You may be seated. Next question, sir.
And you would say from that general distance, you were able to clearly lock eyes with a vehicle that was passing you at a speed that you say was too fast?
As I stated before, the vehicle was not necessarily passing me, it was coming straight at me. And yes, I was able to lock eyes.
So it would be fair to say that all you looked at was the eyes then, and not the entire face?
I saw the face of the occupant, the driver of the vehicle. I did not see pants or make out any shirt or jacket or any other markings.
I didn't ask about pants, but
The witness answered your question. Next question, sir.
I would like to get to it, Your Honor. Did you observe the vehicle strike anyone while it was coming towards you?
I didn't. I did not.
After it had passed you?
Yes, I observed the vehicle striking my 3-year-old daughter, Kelsey.
After that point?
I did not.
You stated that when the vehicle was coming towards you, it turned away. It was turning away.
Yes, as the vehicle was coming directly towards our group, it did make a turn from a northwest direction to a westerly direction down Main Street.
Would it be fair to say that that direction that it turned was turning away from you?
Correct. It was turning towards the middle of the street.
But generally turning away from the area that you and your children were standing at that point in time.
Correct.
From your observation, why do you think the vehicle would have been turning away from you?
Objection.
Grounds.
Calls for speculation.
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Calls for speculation.
And you...
Mr. Brooks, sorry to interrupt. How much longer do you have? The only reason I ask is there's some weather coming in and I've had some alerts and I want to make sure everyone gets to a safe location. There's a tornado warning, not for us just yet, but so I'll let you finish, but I may be interrupting if another alert comes in. Are they going on? All right, we're gonna take our lunch early then, and I'll rise for the jury. Sorry for the interruption, Mr. Brooks.
What? Finish my question.
You will. Appearances are as they were before, and now we can all hear better because the audio is turned on. The record should reflect that when we last broke, the court had received information regarding nearby tornado warnings. Ultimately, there were a number of warnings that were issued, some of which affected the immediate area. Our alert system ultimately went off with the lights and the audible voice telling everyone to take shelter. And it has been lifted, and it was lifted just a short time ago, and I had the parties brought back into the courtroom. I know when we broke unexpectedly, it was during the cross-examination for, I believe, Mr. Knapp, and my thoughts are as follows, is to have Mr. Knapp come back in, I presume he's available, and finish his cross-examination. And then frankly, given the severity of the weather that went through, including near my house, and I need to check on my house, is to break for the day. So I know there's jurors who live in the area, potentially, where some of these things happened. I don't want to question everyone about, whether they have power or whether they don't have power. I just think given the gravity of this case and the weather system that went through, I want to make sure people are giving their full attention, and I would like to then break for the day and then resume tomorrow morning. So that's my plan, as is my practice, though I will give the parties an opportunity to indicate whether they think differently, but that's what I'd like to do. From the state?
I understand, and I certainly respect the court's concern for the jurors and their property and their families.
It's not just the jurors. Let me just say, there's a lot of folks that are here attending. Just what I was following in terms of the weather, it's pretty widespread. There were things that happened more south of here. There were things that happened north and west of here. There's people from all over, and I just think, it would be wise to let everyone break for the day and then, check on their things and make sure that there are things that they don't need to attend to as the case may be. So go ahead. Sorry, I didn't mean to interrupt.
Sure, no, and I understand that, Judge. I don't have an argument with that. I just, we obviously have a full slate of witnesses here to go this afternoon. Some have traveled from like the Cudahy area or, some distance, not unavoidable, but my only other suggestion would be to maybe, take an extended break and let people make calls or even go home and check and come back at 3 o'clock or something. If that's a possibility, we could still work for a couple hours yet this afternoon. But whatever the court thinks is best, we certainly will be prepared either way.
I certainly would be open to maybe an extended break so that I and others could do exactly what you just say. But I'll hear from you, sir, if you have any position on that.
Yeah, I do have a position on that. I agree with your first assessment, Your Honor. Mainly because, too, with severity and weather, that can sometimes mess with equipment being the trial being televised. That can possibly interrupt that. And you never know. Some people that may be key to this matter may not be able to come back after an extended break. There's no way to tell at this point. I do believe it would, on the air, just for cautionary reasons, would be wise to kind of break for the day and then reset tomorrow morning or whenever the court feels it's best. I may need to do some checking of my own with some close relatives of my own. And so I will want to put that on record as well.
Thank you. I presume, though, no objection from anyone to at least finishing up with Mr. Knapp. It appeared to me we were close to being done, including whether he's fine with that as well. And he's shaking his head, yes.
I want to state really quick for the record, Your Honor, I'm still, I guess I would say, waiting to obtain a filing that I addressed before we went on record.
I don't know what that means, sir, but I need to bring the jurors out. I need to finish with the cross-examination portion of Mr. Knapp's testimony, and then in all likelihood we'll just break for the day. I'll make, so I understand wanting to maybe come back at a little bit later, but I think it's just best to break for the day. I will entertain, though, over the next 2 days, whether we go a little bit extended to make up for the loss of the afternoon. I'm well aware we have the interpreter here as well, and so I'll have to have the clerk's office communicate with her when we're not on the record as to when she can come back and when we can get that witness back or here.
He's here and ready to go, Your Honor.
All right.
And Your Honor, just for the record, just real quick, there is a jury instruction as a preliminary instruction for use with interpreters. I wasn't sure if the court was aware of that.
I am aware of
Okay,
that.
perfect. Thank you.
I'll have to get that ready. Probably needs a little bit of tweaking, so thank you. I'm aware of it. Give me the number, though, so I don't have to search for it.
60.
60? Okay, thank you.
I was going to ask the same thing. You just said 60, sir.
All right, jury instruction 60, and I'll work on that when we're down this afternoon. So, all right, let's bring the jurors out, and then we'll, Mr. Knapp, you can take the witness stand and be there when they come back in.
Still no addressing of the subject matter jurisdiction, Your Honor.
Mr. Brooks, my previous record on that issue stands. I will not further be addressing it without a proper motion for reconsideration that complies with the statutes.
I just wanted to state that for the record.
So noted. Thank you, everyone. Please be seated. When we unexpectedly broke prior to the lunch hour, Mr. Knapp was on the witness stand, and he was being cross-examined. Sir, you may continue.
I'd like to apologize to the court. I'm not sure where I left off at.
Go ahead and just start back up.
Okay, I'm trying to see if I took any notes that would get me back to where I was before the break. Do you recall making or being interviewed by law enforcement in the days following the incident?
I was.
Do you recall what date that was?
I believe it would have been the 23rd. My daughter was released from the hospital after a stay overnight, which would have been the 22nd, and I believe it was the 23rd. I could be mistaken on that.
Do you recall if that was just to make arrangements for the interview at that time?
The recollection I have was actually being questioned about the incident.
You don't recall making arrangements to be interviewed and then approximately 4 or 5 days after that actually being interviewed?
Again, I don't recall the exact date. In my mind, it was the day after we got home from the hospital. And yes, arrangements were made to meet with a detective.
Do you recall being interviewed on November 29th of 2021?
Again, I don't recall the exact date.
You made reference to Clinton Street being a cross street that was close by. Would that be fair to say?
That is correct.
Do you recall if Clinton Street had any barricades?
I do not recall.
Did you go down Clinton Street at that moment?
Yes, I did, as stated.
Did you recall any law enforcement being present at the Clinton Street side crossing, I guess?
Yes, there was a law enforcement officer on the south side of the street, and as I mentioned before, he helped save a lot of lives by pushing our children back.
Appreciate the extra commentary. I have the summary right here of the interview that you gave with law enforcement on November the 29th of 2021. And reading from that summary.
Your Honor, I'm going to object. Again, for the same reason I objected before. This is in a statement or a supplement by Detective Jeff Adent, A-D-E-N-T, from the Waukesha County Sheriff's Department, in which he met up with this witness. This witness provided information to the detective.
I understand. I don't need the full
Okay.
explanation. I'll just sustain the objection as to the form of the question. I know you didn't fully get it out, but I think I know where you were going, so please rephrase.
With the reference to the statement that I referred to about the long hair, if I was able to show you, would it bring any recollection of what you may have said during that interview?
No, if I stated it at that time, then that was my recollection at that time. 11 months later, my recollection of the statement is that I made eye contact.
I'm not referring to that statement. I'm referring to the statement that reads David, or yes, or wait, let me back up. Were there some confusion with your name in this report?
Not that I'm aware of.
It looks like the officer that was taking the report got a little confused on the name.
Mr. Brooks, you're providing a narrative, so that's not a question. He doesn't have the report in front of him, so please make sure you ask the question.
Do you recall reading from the summary, describing the driver as an African American male with long hair?
As stated, as I sit today, I remember describing the driver as a black male with facial hair and very wide eyes. If I stated that at the time, that was my recollection at the time. As I sit here today, I cannot state that I recall having or seeing long hair.
Would it be fair to say that what I'm reading from is accurate statements made by you to the law enforcement officer?
Objection. For the same reason I mentioned.
There's a lack of foundation as to the question, so I'll sustain it, and if you are able to rephrase, please.
Can I show the witness his statements? Maybe that may bring some recollection back of what was said in the interview.
I'll allow it. If you would give the statement to the bailiff, who can then give it to the state. I don't know if you have it electronically or if we want to use the document camera.
I have it in front of me.
All right. Is it connected to the...
It needs to be given to the witness. Again, I'm going to object. If he's using it to refresh recollection, that's fine, but this witness says it does not refresh his recollection. I'm objecting to any questions after.
I understand.
Okay.
All right.
I object to that because...
Hold on. Let's show. You've asked that it be shown to the witness. It will be shown to the witness. Is there a particular paragraph you want to direct his attention to, Mr. Brooks?
The paragraph that I referred to when he stated that the driver was an African American male with long hair.
All right. So, sir, just take a moment to review that. When you're done reviewing it, turn it over, and then Mr. Brooks will ask you some follow-up questions.
For the record, I don't consent to being called that name, Your Honor. For the record, I'm third party to the matter, Your Honor. My name is Darrell Brooks Jr.
Go ahead and ask a question to see if it helped refresh his recollection.
From reading that summary of the interview that you gave with law enforcement, do you recall stating that the driver was an African American male with long hair?
I recall stating what I stated before, that it was a black male with facial hair and white eyes. I don't recall stating long hair, but
would it be fair to say that the summary that is in front of you states that that's what you said?
It would be hearsay.
Browns. I'm stating directly what it says on the paperwork.
It's still hearsay, Mr. Brooks. So the objection is sustained. Next question.
Is it fair to say that that's what
That's hearsay. So,
it's hearsay when it's right there for him to read?
Mr. Brooks, I direct your attention to the hearsay statute, all right, for a definition in 908.01 and the rule in 908.02.
So it's not a fair...
Sustained. Next question.
Do you recall if the driver had hair? Any hair whatsoever?
I recall seeing facial hair.
Any hair on their head?
I don't recall at the moment as we sit today picturing exactly that if I saw hair or if I didn't.
any reason why you wouldn't be able to see the driver's head?
My eyes were locked on a vehicle that was driving at a high rate of speed with the person driving the vehicle's eyes extremely wide. And then at that moment, my full attention went to my children where that vehicle was driving at a very high rate of speed.
So it would be fair to say that because you keep making reference to the eyes, so would it be fair to say then that because you were so fixated on the eyes that it would be hard to tell any other features of the driver?
I'm stating what I saw: wide eyes, black male, facial hair.
Would it being so fixated on the eyes, would that in any way make it hard for you to see any other facial description?
I'm not sure of your definition of hard. I'm stating what I saw.
No further questions.
Any redirect? All right, thank you. Sir, you may step down. So, ladies and gentlemen of the jury, I have made a determination that today we are going to break early, just given all of the weather issues that happened earlier today. Frankly, including the need on my part to check on my house and other things. I just felt it best, just given all of that and the disruption, that we would break for the day. I do want you, as you go back home today, to look at your schedules for the next 2 days, because I may keep us here a little bit later to make up for some of the lost time, at least tomorrow. So just let the civilian jury bailiffs know tomorrow when you come in. I do want to read to you the instructions that I've been providing to you regarding not starting your deliberations and the extra research, etc. So, do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law. Tomorrow at 8 a.m. I'm going to check with the jurors, and if anything changes, we'll let the parties know, but otherwise plan on being here at 8 a.m. tomorrow.
Will there be an interpreter? Will you be calling?
I won't know. We'll do that off the record. I don't know if Dawn Maldonado stayed or not, but if not, we'll contact her and we'll be in touch with you very quickly so that we can tell you if that witness needs to come back tomorrow or another day, because it might not be her. They could turn to one of our other interpreters. Okay. All right, thank you everyone. We are in recess. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge Sue Upper, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning. Please state your name, sir.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not identify as that name nor consent to being called as that name.
What is your name? Brooks.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes. He's wearing a suit and tie. He's also wearing a mask. All right, we are starting a little bit early today, given the extended break we had yesterday. Anything the parties wish to take up prior to the jury coming out from the state?
Just one thing, Your Honor. For the record, we have served all of the subpoenas for Mr. Brooks at his request. The subpoenas had indicated a report date and time of tomorrow, which would be October 14th at 8 a.m. Given where we are in the case, we do not believe that we will be have rested the state's case by 8 o'clock tomorrow morning. We believe we're probably on track to rest sometime on Monday at this point. So with the court's permission, we would like to advise those witnesses that they do not have to report at 8 a.m. tomorrow, and that we will update them probably Friday afternoon as to a date and time to appear.
All right, thank you. Any objection to that procedure, sir?
No objection. Just wanted to state that those subpoenas were filled out, as you know, by your assistants, that they should have been filed with the date of the 14th at 8:30 a.m. So just wanted to state that for the record. And also, again, I do not consent or agree to being called that name. My name is Darrell Brooks Jr.
Your lack of consent is noted. I would note, though, you've not provided me with a different name. Number one. Number two, every inmate communication form has the name Darrell Brooks Jr. So I like to refer to the defendants by their name, frankly, out of respect for them, to not continually use defendant over and over again. Not that that would be improper, it's just a practice. So I'm going to still keep referring to you as Mr. Brooks. I know you as Mr. Brooks. Again, you've filed all sorts of inmate communication forms with that name, and you've never given me another name for which to call you. So I just want you to know that's not a disrespectful thing. It's out of respect for these proceedings. But at times I'll still refer to you as the defendant.
No disrespect taken whatsoever, Your Honor. And for the record, I still would not consent to that name or agree to that name.
All right.
No respect, no disrespect taken whatsoever.
Your position is noted. All right, do you have any documents to file today, sir?
Yes, I do.
All right, if you could hand that to the bailiff.
Just very brief things I would like to put on the record.
I'll have the bailiff first show it to the state, as that is proper, and then it'll come to me.
Thank you, Deputy. All right, the record to reflect I have received a document that has a caption for this case, a heading that says bond, then 2 short paragraphs, and then a signature at the bottom with the name Darrell Edward Brooks Jr., authorized representative of Darrell E. Brooks, all rights reserved. I've reviewed it, sir. I would note it will be made part of the file. You do not reference any law as it relates to this request, or what I would deem a request. There's no constitutional provision, statutory provision, or common law associated with this. I'm not sure what you're asking me to do with it as well. I don't see a clear request for relief as well. So it will be filed, but I'm not going to address it any further. Do you want a copy of that for your records, sir?
Yes, I do. The time-stamped original copy, if I may. And also, to my knowledge, the filing is proper, unless Your Honor can provide verified law of your own that is not a proper document. I think it's very clear what the document is referring to. The language is all together. It's a very, very clear document in its entirety. And
Mr. Brooks, I would direct your attention to section 802.01, which governs motions, how made, and the form. That document does not comply with that. As far as receiving a time stamped, we have a date stamp. It will be scanned and it will be then uploaded into the file. I would just note for the record, it's now 8:07, and I've had that for a couple of minutes now, but that's, we don't have a time stamp in the courtroom here.
what was the law that you cited?
I draw your attention to section 802.01, which is the statute related to motions.
And does that refer specifically to that filing?
It refers to any request that's made to a judge or in a court of law. Could, I suppose, go to a court commissioner, but that's not where we're at in these proceedings. That, to me, does not provide a legal or factual basis for the request that you're making. So that's how I will address it.
For the record, I believe it does, Your Honor. It was presented in the same fashion that all my motions in this court have been presented, and you never cited the same thing with the other filings. So that's leading me to believe that it's just that document that's not being accepted when I have the other timestamp filings for the same documents that I filed. Every other document is filed in the same manner. Every last one of them, and no exception with that one, Your Honor.
I understand my obligations with individuals who are representing themselves to review their pleadings and to construe them liberally. However, you were notified the other day that future requests needed to comply with section 802.01. Even with a liberal reading of that document, I'm not sure what it is you're asking me. It's not going to prevent this court from proceeding forward and continuing on with the trial and having the jury brought in and the next witness called.
For the record, Your Honor, can you state why? Because it's clear what this is referring to. It's referring to why there's no bond mentioned or stated in the court document, the docket sheet. There's no bond in any of these writings. Not one time does it mention it, and so that was what this was referring to.
I understand what it's referring to, sir.
Also,
there's no legal basis for your argument.
Also, for the record, this docket is not a certified copy, which is what I requested.
I do not control the clerk's office. You need to make a specific request to the custodian of the court record, which is the clerk of court, for a certified copy.
I did
that
that,
can't
Your
be done here in this courtroom. You have to do that through an inmate communication form.
That's what I did, Your Honor. The ICF should be on record that I specifically requested. I specifically requested a certified copy.
Sir, I'm not in charge of that, so I'm not going to address that any further. So my understanding is a certified copy was provided to you.
This is not the certified copy that I'm holding, Your Honor.
Again, you can take that up with the clerk of court. That is beyond the scope of what I am addressing here. I am not the custodian of the record. I would not be the judge to address any concerns that you have if you believe your request was not complied with.
It clearly wasn't, because
I'm not the person to do that, sir. It's not the proper venue in this case or forum All right, the custodian of the record needs to reply to that. That is our clerk of court. If you believe she did not do that, then you have recourse available to you, but it's not through this case. So with that, I'm going to move on. Let's have the jury brought out.
I was not provided with exactly what I asked for. If I'm told by the court to submit an ICF for any requesting, and I requested specifically a certified copy of the docket sheet and was not provided with what I specifically asked for, then
Sir,
how?
I can't address that any further. So
I
again,
would like
you need
that
to take
stated.
that up with the clerk of court, and you can communicate directly with her office.
Can
But I'm
I
not
be-
going to do it through this court proceeding.
I would like that stated for the record that I did not receive what I specifically asked for, and I'm sure that the ICF is on record. I can get.
Mr. Brooks, for the record, we're on the record. And so
Okay.
everything that we're saying is on the record. So it's noted. Bring the jury out, please.
Also, I had one more thing I wanted to state for the record,
Go ahead.
which was also submitted via inmate communication form. So that should be on the record and it should be filed. I know it should have been received by now. It was addressed to Miss Monica Paz, and it was asking for the complaint that was filed. It was 3 different complaints, and they're found in the docket sheet. One from 11/23 of 2021, one from 11/29 of 2021, which would be the amended complaint, and then one from January 12 of 2022, which would be the second amended complaint. I specifically asked for copies of those to be provided, as they were not in any discovery.
Go back out, Teresa. Hold on 1 second, okay? Sorry. Mr. Brooks, I am not going to answer for Clerk of Court Paz. She is the custodian of the record. All right. So you're going to have to communicate directly with her. If you're looking for just copies, I'm happy to print those off for you. I've already provided some of those things to you. I hear you saying you want certified copies. That would not be provided by me. Are you looking for certified copies or just copies?
Certified copies.
All right, then that will have to be addressed by Clerk of Court Paz.
So how would I do that? Because
I can't, sir. I've
is it
already
through-
told you need to make the request to her. That's how I have to leave it, sir. I'm not the custodian of the record, so.
I addressed it that way, Your Honor. I addressed it the way I was told to address it from
My
the court.
understanding is it went to her. So with that, let's have the jury brought out. Your position's noted.
Your Honor, can we address the subject matter jurisdiction before the jury comes out? The jury comes out?
We've already done that.
And is that a judicial determination that you're making not to address the subject matter jurisdiction, which has yet to be proven at this point? It has not been
Mr. Brooks,
verified?
please, the jury's coming out. I know what you're doing, but I've already addressed that.
So is that a judicial determination that you're making?
My decision on the record stands, sir.
And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever. And that by refusing to answer, that is a tacit agreement by you, Your Honor, which you understand what that means. I know you do.
Mr. Brooks, I have not entered into any such agreement, and because the jury is out and you are claiming that there's some issue, I'm going to take this up later, but I will entertain a request from the state for a curative jury instruction. All right, thank you, everyone. You may be seated, and welcome back, ladies and gentlemen of the jury. We are proceeding with this trial, and the state may call its next witness.
And Your Honor, before the state calls the next witness, I just want to let the record reflect that I did put Exhibit 54 on the witness stand, and it will be introduced through the next witness, who is Laura Thien.
All right, thank you. Good morning, Ms. Thien. If you would please make your way to my witness stand, which is all the way up by me.
In November, would you have a pretty standard formation that you would keep to do each of your routines during the parade?
Yes.
Did you have uniforms?
Yes, we did.
Can you describe them for the jury?
Objection, relevant.
Overruled. You may answer.
Grounds for the
They were long skirts with white fur. They were blue with white fur on the bottom. Blue jackets with white fur for cuffs and around the neck, and a white fur hat.
Did you have, I'm assuming if you were dancing to music, that you had something that played the music?
Yes, we have a music vehicle.
Where would that music vehicle be in relationship to the group who was performing?
Right behind the group.
Oh, hold on. There's been an objection. It's noted. It's overruled. Her answer may stand. Just in the future, if there is an objection, wait until I've ruled on it and then answer if I say overruled. Okay?
Okay.
Thank you.
overruled.
Relevant.
Grounds for the relevancy.
Keep going.
Thank you. So did you also have people walking with the performers in the parade to give support?
Yes, we have volunteers. We have 2 volunteers that carry the banner and a volunteer that will give us ice chips in case we get.
Okay. Do you recall who were the 2 volunteers who were carrying the banner that day?
Yes, there was our usual banner carrier, a young girl, Allie, and then at the last minute the gal didn't show up because we have 2 for the banner. She didn't show up, so Ginny at the last minute decided to be the other banner carrier.
Now when you say Ginny, are you referring to Virginia Sorensen?
Yes.
And you knew her as Ginny?
Yes.
Okay, and you said there's also another support person who carried ice chips.
Yes.
Do you know who that was last year?
Objection, relevancy.
Overruled. You may answer.
Grounds for the overrule.
I should have.
You can answer.
Okay. Yes, Bill, one of our dancing grannies' husbands.
Is that Wilhelm Hospital? Is that his full name?
Yes.
Okay, thank you. Now I have before you a document that's marked States Exhibit 54.
Okay.
Do you see that in front of you?
Yes, that's pretty much our group.
Okay. So it consists of 9 different, it looks, why don't you describe for the jury exactly what's in front of you?
Objection.
Overruled.
Grounds.
You may answer.
Okay, we have 9 people that were in the parade. And when there are an uneven number, there is somebody who is in the slot.
Okay.
And it was my turn to be in the slot.
Okay.
So.
Okay. So on the top of the sheet, and I have a copy in front of me, so if we're going from the top down, we have the names. It says banner, and then on the left-hand side, as I'm looking at that, it's Ginny Sorensen and Allie. Is that correct?
Yes.
And I'm going to actually ask that this be published also for the jury and admitted into evidence.
Objection. And we have yet to see what's being talked about being shown.
Does Mr.
It's up now.
Brooks have a copy?
I believe it's up in front of him now.
All right. Give him a minute to look at it.
Objection. I do not consent to being called that name, nor do I agree to being called that name.
What is your name? Brooks.
All right, the record should reflect that the Exhibit 54 is being displayed on the monitors at the present time to the parties, to the court, and to the witness. There's been an offer or a request by the state that the court receive the exhibit based upon the testimony of this witness. Exhibit 54 is received, permission to publish is granted.
Objection.
Noted. Overruled.
On what grounds?
Mr. Brooks, I'm not going to be specifically addressing, so please respect that.
I respectfully request a legal reconsideration of your ruling.
Mr. Brooks, now is not the time for that. The objection has been overruled. I expect that you will honor that, and we will continue without interruption. Go ahead.
I do honor it, Your Honor. For the record, I respectfully respectfully reject that ruling and take exception to that ruling.
Keep going.
Thank you. So in the upper left-hand corner, the name Ginny Sorensen. In the middle, it says banner, and then Allie. Ginny was Virginia Sorensen. She was carrying the banner with Allie, correct?
Yes.
And they would be in the front as the group is going down the parade route?
Yes.
And the 9 people who are listed in the boxes following or behind the banner, does that accurately reflect the lineup that you had on November 21st of last year?
Yes.
Okay.
Overruled. Her answer may stand.
Wow.
Your Honor, I'm now going to show the witness exhibit 53, just the witness only.
Go ahead.
And let me know when you see it up on your screen.
It's done.
Okay. I'm going to show you a couple seconds of it. I'm just going to ask you if this accurately depicts your group on November 21st of last year. So I'm going to play a couple seconds. It's starting at 00, and let's play it for 5 seconds.
This is my group coming up.
Okay. And does that accurately reflect how your group on November 21st of last year? Okay.
Sorry, you were shaking your head. Yes. Is that a yes?
Yes, that's how it was.
Thank you.
Oh, I'm sorry. I should have said it out loud.
It's okay.
That's okay.
That's what I'm here for, to make sure the record's clear.
Okay.
I would ask the court to admit this exhibit 53 into evidence and publish it for the jury.
Objection.
Overruled. Exhibit 53 is received. Permission to publish is granted.
Grounds for the overrule.
Ma'am, I'm going to play it straight through, and then we'll go back and go through it and pause it occasionally for you and to identify everyone, okay?
Grounds for the overrule, Your Honor.
The state may continue.
All right, is that a legal determination that you don't have to give me the grounds for the overrule as I objected on the
Mr.
record?
Brooks, stop interrupting. I've made my ruling. Let's keep going. Go ahead.
Thank you.
I ask for a written judicial finding of facts and conclusion of law. Or is that a tactic agreement, Your Honor?
Your Honor, just for the record, this is 1 minute and 27 seconds long. Bam, that was the routine at the beginning of the parade, it looks like.
Yes.
Is that correct? And will you be able to identify each of the people if I go through the exhibit and kind of pause it occasionally for you to tell us who they are and a little bit about them?
Objection, hearsay.
Thank you.
Overruled.
Grounds for the overrule.
Not hearsay. Go ahead.
Okay, so I'd ask that we begin playing it without sound at 00. If we can pause it. The left side of the street was where Lee Owen was, or the left side of the picture as you're looking at your screen.
Lee was on the left, right behind Ginny.
Miss B.
Oops.
It's okay. There's been an objection. It's overruled, but I would caution the state about leaving the witness.
Okay.
Go ahead. You may answer.
Okay, so
Okay.
right behind Ginny was Lee Owen.
Yes.
Is her full name Leanna Owen?
Lee was
Overruled.
Lee was very close to Ginny. They worked together a lot for the group, and she taught a lot for the new people that were coming in. She was more or less the leader to teach them the routines, something like that.
Hold on. There has been an objection.
Okay.
I'll sustain the objection on leading grounds. Her answer may stand, but I would again caution the state to.
And I would just note for the record, Exhibit 54 is in front of this witness, and it does have the first and last names, and she's already said that it accurately reflects the people who were marching with the dancing grannies on November 21st of last year?
That was not the question. It was leading.
Understood. For purposes of identification, though, I'm going to instruct her to turn the Exhibit 54 over to make sure that her testimony today is from her recollection and not from reading from a form. So if you could turn that over, please. The paper document that you have. There you go. Thank you. Go ahead.
Now you circled, can you circle Tamara Durand again, Tamara?
Okay, this is Tamara Durand.
Okay.
This would be Kathy Z.
Okay. Directing your attention to Miss Durand, can you tell us a little bit about her?
I'm sorry.
Directing your attention to Miss Durand, can you tell us a little bit about her?
She was new, and this, again, was her first parade. She was so excited about being a granny because she had worked for months and months to learn all the routines. And when she knew she would be in that Christmas parade, she was so excited. She just couldn't wait. So she was looking forward to doing all the parades. That was the first and last parade she ever did.
If we can clear the screen and continue on with the video from 42 seconds. If we can pause it. Okay. Last but not least, hopefully you get this one. Okay, that's you.
That's me.
Okay, if you can circle you on the diagram, I think there's only one person in it. And you said you've been with the Dancing Grannies for 8 years, correct?
Yes.
Okay, if we can clear this, and I stopped it at 1 minute and 9 seconds. If we can continue forward. I'm going to pause.
That's the music vehicle.
Who drove that vehicle on that day?
Pardon?
Who drove the vehicle on that day?
My husband.
Okay. And you see a figure entering into the screenshot. Do you know who that is?
This would be Bill.
Okay. Thank you. And that's Bill Wilhelm?
Pardon?
Do you know the last name?
It's been rephrased.
Hospital.
Okay.
That would be Bill Hospital.
Okay. And do you recall him wearing a hat that day, as shown in the picture?
Objection, leading the witness.
Overrule.
Grounds.
Relevance. You may answer.
Okay. Bill was just walking up behind Tamara Durand and going to be offering her some ice.
I'm not sure you heard the question. If the state could re-ask it.
Certainly. In looking at the picture, was Mr. Hospital wearing a hat that day?
Oh, I'm sorry. Yes.
Okay. And during pretty much the entire route of the parade, was he usually in back of you or in front of your position?
He's on the side of us.
Okay. And usually on the side that he's on right now?
Sometimes he would be on the other. It just depended how many people we had to give ice on any particular parade.
Okay. And was it cold that day? Do you remember?
Yes, it was pretty cold.
Okay. I did stop the video at 1 minute and 20 seconds, and I am done with this exhibit. At some point during the parade, did you hear, strike that, were you always, with the formation that you've testified about, were you always the last dancer in the formation?
No.
On November 21st, 2021, were you the last dancer in the formation throughout that parade route?
For this parade, I was.
Okay.
We took, if there's an even number, nobody is in the slot. But if there's an odd number, there was no partner, so we just would take turns. Each different person at each different parade would be in the slot.
Okay. So at some point, did you hear something unusual behind you during the parade?
No, because the music vehicle was right behind me.
Did you at any time turn around and see something unusual?
Yeah, as we were going and I was dancing, when I would turn I seen a streak of red coming on my right side.
How fast was that streak of red going?
It was going pretty fast.
Hold on. The objections noted, it's overruled. Her answer may stand.
Grounds for the overrule.
Relevance.
So your answer stands, which you said it was going pretty fast?
Yes, it just like whizzed past me. It wasn't just going slow.
As it was going past you, who was in the area prior to it going past you on, and I'm assuming you lifted your right arm, was that on your right side as you were marching down Main Street?
Yes.
Okay. Who was in that area prior to that red streak coming through?
Kitty corner for me, that would be Bill and Tamara Dorow.
Did you get the opportunity to see what that red streak was?
Yeah, and shortly, in a few seconds later, the red vehicle was right in front of me, going down the center of, to me, just pointing to the center of the parade route.
So right in front of you?
Yes.
How close did that red streak come to you?
I would say a few feet. He had to go around the car, the music vehicle.
Okay.
And then the right on the right side, and that's when Bill and Tamara were hit.
So when you were in front, in the back of the parade lineup, how far were you directly in front of the music car?
Several feet.
And the red vehicle that you've identified, it went to the right of the
It came
music car?
from the right side, yes.
And you stated it hit Bill and Tamara, correct?
They were the first ones, because they were just kitty corner from me, several feet.
Then where did it go? This vehicle.
Then I noticed, I didn't see them get hit, because it all happened so quick that I was still dancing, and all of a sudden I seen the red car in front of me, and I screamed either in my head or out loud, I don't know which, but I said, "What is he doing? Where's he going?" And I just screamed it because it was so unusual, and I knew if he was going down the center of the parade route, he was going to be hurting a lot of people. And he wasn't going slow. He was going at a good clip.
Did, from the time that you saw the red vehicle on your right, striking Bill and Tamara, did you see it slow down at all?
Did I what?
See the vehicle slow down?
No, it just hit them, and as he was coming in, he started then going toward the middle, where he hit two more people, and then veered to the left and killed two more.
You said it was a red vehicle. Did you get a general description of the vehicle? What type of car? Was it a car, a sedan, a pickup truck?
No, it was like a SUV or something. It wasn't just a car. It was a van or, something on that order, SUV.
So as the vehicle went through, did it stop after it struck, I think you said it struck the people in the front. Who were the people that you just testified to that died?
Objection, leading the witness.
Overruled.
Grounds.
He came from the right. Hit two.
Whoops. Sorry.
Was not leading. Go ahead. You may answer.
It came from the right, hit two people, and then veered toward the middle. And that's when I really seen him. And then hit 2 more people, veered to the left, and hit 2 more.
And the last 2 people that were struck, do you know who those people were?
Yes, I believe they were Ginny and Lee.
And you testify that both of those people died as a result of being struck?
They were killed instantly. And because the car came from the back, oops.
That's okay. There's not a question. Wait till the question is asked.
Okay.
After the car struck Ginny, and she would have been in the front of the parade still carrying the banner, is that correct?
Yes. She was on the far left, right in front of Ginny.
After that occurred, did you see the vehicle stop?
No.
Vehicle kept going?
Yes.
Did you see the path of travel it took after it struck Ginny?
Well, after it struck Ginny, it was sort of on the left side of the street, and it just kept barreling through.
I'm going to bring up Exhibit 54 again.
Go ahead.
And I'd ask that be published to the jury. It's previously been admitted as evidence. Go ahead.
Objection. What's the relevancy of the video?
It's Exhibit 54. The court's already admitted it. It is shown to the jury. Go ahead.
Ma'am, can you, when the car went through, can you approximate where Bill was on this chart? You can put an X where you think he was.
Bill was about here.
I thought the sheet wasn't being shown. You specifically made a ruling for the sheet to be turned over.
That was during her testimony. She's now being asked to annotate the exhibit. So it's proper. Your objection's noted. It's overruled. Go ahead.
Thank you. Can you show the jury, using this chart and maybe you just using a line, the path that the red vehicle took?
It struck there, hit Tamara, Betty, Lee, and then Ginny.
Thank you. If we can take a screenshot of that, and it would be State's Exhibit 54A, I believe. And you stated after it struck your group, it continued going in the left hand?
Yes.
Side? Do you know what group was in front of you?
What was in...
I'm sorry, do you know what parade group was in front of the dancing grannies? And if you don't remember, that's okay.
Yeah, I'm not real sure.
Okay, that's fine.
For the record, the court did capture the annotation and marked it as 54A.
Went into shock, and I just grabbed my jacket like this and went to each body to see who it was and if I could help.
You said that you grabbed your jacket. You held both sides of your jacket up to your neck area. Would that be a fair statement?
Yes, I think I needed...
Hold on. Okay. The objection's noted. It's overruled. Her answer and the description provided for the record by Attorney Basie, I would note, was accurate. You may continue.
Grounds for the overrule.
Already noted. Go ahead, Attorney Basie.
So you said that you were in shock.
I just went into shock, seeing the bodies. I needed to hold on to something, I think. So I just grabbed this and just went from body to body. And then the people were running into the road with blankets, and anybody that was in the medical group quick came and were helping the people that were laying in the road to see if they could help.
The people that you saw laying in the road, were all of those people from your group?
Objection.
Yes.
Hearsay.
Overruled, not hearsay. Just a reminder, once again, let me rule on the objection before you answer. It's okay.
I'm sorry.
Go ahead.
Thank you. And did you go by Bill Hospital?
Bill was on the right side. He kind of was thrown on the sidewalk.
Did you go by him at all, or?
Yes.
Objection.
I talked to him.
Hold on. There's been an objection.
Oh, I didn't hear him.
It's overruled, and her answer that she gave me.
I didn't even state the objection, but
I'm going to show you what's been previously marked and admitted into evidence, which is Exhibit 15. It's going to show up on your screen, okay? Let me know when you see it in front of you. And I'd
Okay.
ask that it be published to the jury as well. It's previously been admitted into evidence.
Go ahead.
Thank you. Ma'am, can you, is this look to be Main Street, the parade route from November 21st of 2021?
Objection. Leading the witness.
Sustained as to the form of the question. Please rephrase.
Do you know what Exhibit 15 is?
No, I don't know what this really is.
Okay. Do you see, does it appear to be a map or something else?
Objection.
Pardon?
Leading the witness.
Overruled. She may answer that.
Does it appear to be a map or something else?
Yes, where there's a lot of names and kind of a map.
Okay. Do you see a purple line on that map?
Yeah, with all the purple stars on.
Or I don't know if they're purple stars, but I see some yellow stars, some orange stars.
Yes.
Objection. Leading the witness.
This has previously been marked and admitted into evidence. I think I can direct her attention to these items.
Agreed.
I think
Your objection is noted. It's overruled. This exhibit has previously been received.
I think the stars the color are pretty obvious what they are.
There's various color stars, and
There's
again,
only
the
two
exhibit's
color
been
stars.
received. The jury can determine for itself later on what colors they are and the meaning of them. But go ahead. You may ask your next question of this witness.
And you see the street that, the long street that's depicted on Exhibit 15. Do you see a name on that street?
Okay,
Do you see it?
yes.
And what is it?
I see all the stars. I don't know what the question.
Do you see a name on the street on the map?
Okay, let me see.
For example, oh, go
Main
ahead.
Street, Broadway.
So is Main Street the street that you were on when you were marching and your group got hit?
I believe it was.
Okay. Now, if you go to look to the bottom left, there is a box that's labeled Dancing Grannies. Do
Yes.
you see that?
Yes.
And it has 7 names in that box. Are those all part of the Dancing Grannies?
Objection. Leading the witness.
Overruled. She may answer.
Grounds.
She
I
may
may
answer.
answer.
Go ahead.
With the exception of Bill, he was Lola's husband.
Yes. I'm sure he would appreciate that distinction that he was not one of the dancers.
Right.
All those people were associated with the Dancing Grannies?
Yes.
And the people in red are the ones that you testified are deceased as a result of being struck that day? Is that correct?
Yes.
Okay. And the other 3 that are in green are those people who were injured as a result of being struck that day?
Okay, 1, 2. Yes, Lola wasn't really injured. She just was with Bill when he was injured
Okay.
to keep him calm.
Okay. And you see that there's a black line that directs it to a yellow star. Do you see that?
Objection. Leading the witness.
Yes.
Overruled. This exhibit has previously been received. It's fair for the state to direct the witness's attention to a particular part. And her answer may stand.
Does that appear to be the location where your group was struck?
Okay, yes.
It does?
It looks like it would be, yes.
Thank you. We can take that off the screen. And was that the path of travel you recalled seeing the red vehicle take as it went by you on the right and went through your group?
Yes.
Okay. I want to show it one more time for the jury so that they can now focus on the headlights on the vehicle.
Objection. Relevancy.
Your objection's noted. It's overruled. Permission to publish once again
Grounds.
is granted.
And Your Honor, the state is going to play it at 50%.
Grounds. Objection. Grounds.
Noted. Overruled.
Grounds.
Relevance.
If you can start,
And-
please.
I request legal reconsideration of your ruling.
Denied.
Grounds of the denial. For the record, may I request a legal or factual basis for your ruling? Is that a legal determination, Your Honor? Are you making a judicial determination?
You may continue, Attorney
Ma'am,
Basie.
did you see the body come forward and fly in front of the truck?
No, me being in
I'm
back.
sorry, in the video, did you see the body
Objection.
flying in front of the truck?
It's not
No.
leading.
In the video that you just saw, you didn't see a body?
Oh, yeah, on the video, but not.
Right. And do you know who that was?
Yes.
Who was that?
When they had it on TV, that was
No,
the man, right?
I'm sorry. Who was the body that went flying in the street that came towards the front of the screen?
Hold on 1 second. That last answer, I'm going to, because it was non-responsive, but I'm going to strike it, instruct the jury to disregard it, and then if you could state your question again.
Certainly. If we can go to Exhibit 55 again, to approximately the 10-second mark.
Are you withdrawing that last question then?
Yes, I am.
Okay, thank you.
Can that be struck? The question?
It's been withdrawn.
Can it be struck from the record?
It's been withdrawn.
May it be struck from the record?
There does not need to be struck. So the request is denied. It's been withdrawn.
May I ask for a legal and factual
Remarks
basis
of
for
the
your ruling?
attorneys and questions of the attorneys are not evidence. It's the answers that are evidence, so that's why it's not being struck. You may continue, Attorney Basie.
Thank you. Do you see a body probably in the middle of the screen on the left-hand side? On the ground?
Yes.
Do you know who that is?
Well, it's hard to tell who it's, but that would probably be Ginny.
Okay, with some. Ma'am, who did that red vehicle strike in that exhibit, Exhibit 152?
Objection. Leading the witness saw the video.
Tamara
Saw the video.
Dorow.
Hold on, there's been an objection, everyone. The objection is noted, it's overruled. Now you may answer the question.
Grounds for the overrule, Your Honor.
It's overruled, you may answer.
Grounds for the overrule, Your Honor.
Go ahead, you may
Tamara
answer.
Duran.
Thank you. I'm now going to play it at 50% speed for the jury. And that was the car that you saw travel in front of you?
Yes.
Objection. Leading the witness.
Overruled.
Grounds for the overrule, Your Honor.
It's overruled. Next
Grounds.
question.
Ma'am, I'm now going to, if I did not already do it, I'd ask that Exhibit 152 be admitted into evidence. I would then direct the witness's attention to Exhibit 153, which will show just in front of your screen, okay?
Grounds.
Exhibit 152 was received already. No need to address the request for grounds by Mr. Brook due to that. And then the exhibit is up in front of the court, the witness, and the parties, but not published.
Objection. I do not consent to or agree to being called that name, Your Honor, for the record.
Go ahead, Attorney Basie.
Thank you. This clip
Would that be
is...
noted for the record, Your Honor?
Go ahead, Attorney Basie.
Thank you.
May
This-
that be noted for the
Mr.
record, Your
Brooks,
Honor?
stop interrupting.
I just want to make sure
Mr.
it's
Brooks, stop.
I just want to make sure it's on the record.
Go ahead, Attorney Basie.
Thank you. This clip is 38 seconds in length, Your Honor. Again, I'm going to show you the first 5 seconds of this clip and ask if it accurately reflects your observations from November 21st of last year. If you can start. Ma'am, is that your group in the Waukesha Christmas Parade last November?
Yes.
Okay. I'd ask that Exhibit 153 be admitted into evidence and be published for the jury.
Objection. Relevancy.
Exhibit 153 is received. It may be published to the jury. The objection is noted and overruled.
Ma'am, I'm going to have it played at full speed, and then I'll ask you some questions and then play it at half speed, okay? Ma'am, what did you see in Exhibit 153 that was just played before you?
I seen Bill being hit and thrown towards the sidewalk.
And that's Bill Hospital?
Yes.
And I'm going to show it now to you and the jury. Just a clip of it, starting at 0 seconds at 50% speed. What I'm going to be asking you about is where you are in this clip. Okay? So if you can start it. I see we may have a future granny in front of us here with the green hair.
Sure looks like it.
Objection. Relevancy.
Your objections noted, sustained. The jury will strike that last question and answer. I mean, the jury will disregard that last answer.
Now, if you look at the street, pause. Sorry, keep going. If we can pause it now at 21 seconds. I would just ask, did you see after Bill Hospital was struck, did you see some feet coming through the screen on the bottom at the very end of that clip?
Objection. Relevancy.
I seen him in the legs, yeah.
Okay. And then did you see your feet marked? That would have been the approximate area that he was hit. Did you see your feet in the video at the end? It's fine if you didn't. It's
Not really.
Nice. Okay. Thank you. Nothing further. Thank you.
Ma'am, I'm going to give Mr. Brooks an opportunity to ask you questions as well. Please answer those for him. Go ahead, your cross.
During your testimony, you kept referring to he. Who were you referring to when you said he?
I can't understand him.
Can you please state your question a little bit louder? She was not able
Yeah.
to hear.
I apologize. I'm sorry.
You need to be closer to the microphone or project your voice, okay?
I got it.
Thank you.
During your testimony, you kept referring to a he. Like a lot of times you would say he. Who were you referring to by the he? Who did you mean by the he?
He?
Yes.
When it was showing Bill,
No, not
Bill would be the he.
Before today, have you seen any of those videos before today?
No.
You stated that you saw a red vehicle strike the grannies. Do you remember if that was, or let me back up. Do you remember what type of vehicle you saw?
It was like an SUV. It wasn't just a car. It was, the flat back. I'm bad for cars. And all I know is I seen the red streak, and then all of a sudden I seen the car in front of me.
So would you describe it as a car?
It was a vehicle.
And how close did it come to you, if you recall?
I would say several feet. I was in front of the music vehicle, and it came around the music vehicle on the right side, and that's where Bill and Tamara were. And I was a little bit this way because I was directly behind the music vehicle.
Were you able to see into the vehicle in any way?
Was I able to what?
To see inside of the vehicle?
No, because it came behind me.
So you didn't get a look at the driver at all?
No, I don't have eyes in the back of my head.
You stated that there was a music van of some sort?
A music vehicle.
And you also stated that you couldn't hear what was going on behind you because the music van. Would that be fair to say?
That's right. I didn't hear anything. I just seen a red streak when it came past me.
So would it be fair to say that if a vehicle was honking a horn, you wouldn't have heard it if it was behind you?
I don't know. No, there was no horns.
But you don't know for sure because you stated that the music was playing pretty loudly. Would that be fair to say?
That's for sure. But whether I would hear a horn or not, I don't know.
Were you able to see a license plate number of the vehicle?
No. I was just shocked that a vehicle would be in the parade route. I didn't have time to read a license plate.
And you stated that there's also a member of your group named Lola?
Named what?
Lola?
Lola, yes. It was her husband, Bill.
And she, to your knowledge, to your recollection, Lola was not injured?
No.
You spoke with knowledge of a lot of the injuries. Would that be fair to say?
Yes.
Have you yourself ever had any medical training of any kind?
No, my family is all in the medical field.
Have you yourself ever
No.
been in the medical field?
No.
Did you see anyone behind you struck?
No, because I was behind the music vehicle. I mean, in front of the music vehicle.
And you yourself weren't injured, right?
No. The car couldn't get at me because they would have to go through the car. I had to find a way home because the music vehicle had to stay there because it was a crime scene. So Kathy Z's family took her home, so they gave me a ride right away too.
And you don't recall about what time that was?
No.
That would be fair with everything else going on. At any time in the days following the incident, did you see any reports of a suspect at any time?
I seen it on the news that a suspect was taken, or found, I should say.
And what are you referencing when you say found?
What was I what? Oh, found. In other words, the police found him. I didn't know who, where, or who he was at the time.
I don't recall if this question was asked, so I'm going to ask it. Were you there with any of your family members, immediate family or anything?
My immediate family members, just my husband. And he was driving the music vehicle.
Was he injured in any way?
No. Outside of being shocked by what he was seeing.
Physical injury. Did he suffer any
because
physical?
he was in the car.
Did you ever file any claims related to the incident?
I believe not of the incident, no, because I was there when they were talking to the gals that weren't hurt. They were like interviewing us.
The four of you, correct? The four that went, the
all
two
of us,
cats.
yeah, the ones that were left, yeah.
Do you know if they filed any claims related to the incident?
If what?
Do you know if they filed any claims related to the incident?
Objections?
Grounds?
Cause for speculation?
Grounds?
The way that he asked it is overruled. So you may answer if you know.
Okay, no, because we were all together and came to every interview that they needed from us.
Do you recall seeing or reading any complaints related to the incident?
Objection?
Grounds?
Sustained as to the form of the question. You don't have to answer that.
Okay.
Should I rephrase the question? Or?
It was sustained as to the form of the question.
At any time during any interviews with law enforcement, were you shown a complaint related to the incident?
Objection? Ben?
Grounds?
Sustained as to the form of the question.
Were you informed that it may be a possibility that you might be called to testify in this matter?
A lot later, not at the time. I had no idea of testimony until.
Would you say much later, as you say, would that refer to weeks, months?
Months. I was in no shape at the time to testify or talk about anything.
Do you recall seeking to testify? Wanting to testify?
No, I didn't ask to. This just happened when we would be in our interviews and then.
So it would be fair to say that you were asked or
Yes.
subpoenaed?
Yes.
Do you recall by whom?
I imagine the DAs or.
When you say the DAs, do you mean the district attorney's office?
Yes.
Did they ever identify to you as being the plaintiff in this matter?
Objection?
Grounds?
Sustained. Next question.
Grounds for the substance, Your Honor?
Relevance grounds.
Do you recall ever being told that there was a plaintiff in this matter?
No, it's just I was interviewed a few times, the 5 of us, and that was pretty much the end of it until months ago where
I think probably a little explanation is needed. Are you aware what a plaintiff is?
Objection? Relevance?
Grounds.
Sustained. Next question.
Grounds for the sustain, Your Honor?
Next question, Mr. Brooks.
Grounds for the sustain, Your Honor?
Ask your next question, please.
I am. I just want to know the grounds, just for the record, the grounds for the sustain.
Ask your next question.
Your Honor, the grounds should be put on the record.
Ask your next question. I'll address this all at the next break outside the presence of the jury. Ask your next question.
Your Honor, with all respect, I think the jury
Mr. Brooks, under
deserves.
906.11, ask your next question, or I will determine that the cross-examination is now closed.
I'm
Keep
gonna
going.
ask, I'm gonna keep going. I just think the jury deserves to hear.
Mr.
all
Brooks,
the
I'm
testimony.
instructing you to stop making those statements. The jury will disregard. This is the cross-examination. It's not your opportunity to make legal arguments or to testify. You'll have an opportunity if you so choose to do that later.
With all respect,
Next
that is not
question.
question-fine. The jury just deserves to know.
All right, under 90611, the cross-examination
I still
will
have
be
a question,
determined.
Your Honor.
Sir, you didn't follow my very clear instructions. Does the state have any follow-up?
No, Your Honor.
All right, thank you, ma'am. You may step
Objection
down.
to that, Your Honor.
Your objection's noted. Ma'am, you
I
may
was
step
not-
down, and after she steps down, I will be excusing the jury for a few moments. Please rise for the witness and for the jury as they leave the courtroom. Mr. Brooks, please wait. You may have a seat, everyone. To specifically address the repeated request by Mr. Brooks for the court to state the grounds, sir, I am not legally required to do that. Those are legal determinations that if you feel there is an error later on, you can address on appeal if you are convicted. I have been answering many of them at your request, but I may not do that at all times. In fact, you're asking me to provide that explanation and really highlight for the jury the court's opinion on relevance. That's why we don't state that. There's an objection, a party makes it, states the grounds. Sometimes I ask the opposing party for their position. Sometimes I do not. Many times it's very self-evident. Either the objections are baseless. Many of the hearsay objections are baseless. Your objection to hearsay is it's not hearsay. So that's why, to me, they're self-evident. I say sustained, and we go forward. So you need to be aware, sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury, which I don't feel is necessary for the reasons that I've already stated, that you're asking me to highlight my opinion on relevance and my determination on relevance. So going forward, you need to be aware of that. Again, not a sign of disrespect. It's the record is self-evident many, many times. If I feel that more argument is needed, I'll excuse the jury. But I haven't felt the need to do that up until this point. And I will caution you once again, sir, 90611 is the statute, mode and order of interrogation and presentation controlled by the judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. A, make the interrogation and presentation effective for the ascertainment of the truth. B, avoid needless consumption of time. C, protect witnesses from harassment or undue embarrassment. And it goes on, but for purposes of what I'm going through, that's the most relevant portion of 90611. So when I give you the warning that under 90611, I will cut off your cross-examination, it's because you're violating 90611.
So is that a judicial determination that I violated 90611 when
I'm advising you, sir, it's not a specific determination as to anything that's happened thus far, just a summary of why I am relying upon 90611 throughout the questioning of witnesses and the presentation of evidence.
Your Honor,
so with that, we're going to continue. I'm going to have the state be ready with their next witness.
Your Honor, I'm not interrupting you. I'm letting you make a clear record.
Mr. Brooks, you have actually interrupted me.
I just let you go through the whole citing of 90611 without saying anything.
I'm not asking for the parties to make an argument under 90611.
So
I'm
why
advising
reading?
you. Stop interrupting me, please. I'm advising you, sir, so that you have hopefully more knowledge and awareness as it relates to the statute that I've cited dozens of times during this Trial.
I'm well aware of what I'm citing, Your Honor. Well aware.
All right, so
and I'm just seeking for the record to be clear. With all due respect, Your Honor, that's judicial misconduct because you're not allowing the jury who deserves to hear certain aspects of testimony. Like I stated yesterday, under the Sixth Amendment, I have the right to face my accuser, which means that I can question about clearly the plaintiff being the accuser. How come I can't question about if a witness may know or have had any prior interactions or any conversations or anything of the sort with the plaintiff who has yet to show their face? Also, the reason why I was objecting the way I was is because I was trying to get to the question of the witness saying that about the 4 ladies in her group that were not injured. There's relevancy because with her stating on the record, clearly for the record, and for Your Honor, and for the court and for the jury that these ladies were not injured in any way, but yet there's still charges associated with these ladies who were not injured. That should be dismissed.
we are not at that point, sir. The charges I refer you to the preliminary jury instructions for first-degree recklessly endangering safety and the elements, or the elements they don't need to prove. There are certain elements. And so I'm not going to have a debate with you over the law at this point. I've made my rulings as it relates to certain questions that you have asked and whether they're relevant, whether they're vague, whether they call for speculation, or a whole host of reasons that a question can be objected to. I'm not further going to address your position on
May I request a legal reconsideration of your ruling, Your Honor?
You interrupted me. I'm not done with what I was trying to say.
It was no way for me to know that because you paused. I'm sorry. I apologize.
Just because I paused doesn't mean I'm done.
But you paused for quite a while, so I wasn't sure.
In any event, sir, we're going to keep going. Any error you believe I've made, you can raise again on appeal if you are convicted, but we will proceed forward. Does the state have their next witness available? Please do not interrupt. I'm asking a question.
That's why I was just
Mr. Brooks, you're interrupting. Stop. Does the state have available their next witness?
We do, but could we please request a comfort break, Your Honor? I'm sorry, but we haven't gone about 2 hours now.
All right, that's
as long
fine.
as
We'll
they're out.
take a 15-minute break. That's fine.
Thank you.
You're welcome.
For the record, Your Honor, we haven't addressed subject matter, jurisdiction.
We are off the record, Mr. All right, we are back on the record. Then appearances are as they were before. State have their next witness available.
Yes, Your Honor.
All right, let's bring the jury back out.
Don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. My name is Darrell Brooks Jr. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the military
All right,
power?
Can you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will. I will.
Thank you. Everyone else can be, you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking,
And on what legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information, to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity. As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet. There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything, which you stated for the record a non-responsive answer. A non-responsive answer is an agreement, which would be a tactic agreement by you, Your Honor, that you don't have to answer these questions that you should be answering. I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Has that been placed in the evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment at least, at the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until the appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know, the news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I can reach out immediately when I learn something. That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time for time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that.